Hello, welcome to Legal Action. My name is David Siegel. Thanks for joining us today. My co-host, as always, is Jesse Barrientes. Jesse, welcome to the show.
Thank you, Dave.
We're going to be talking about divorce and family law, and we have two special guests today. Let's start with the Honorable Judge David Garcia. Welcome.
Thank you.
And
Glad
Ms.
to be here.
Angela Henderson
Yes,
from
thank-
Henderson Law and Mediation.
Thanks
Welcome
for
you
having
both to
me.
Legal Action.
Well, I'm glad to be here.
Okay, thank you for coming. Jesse, why don't you start with the guest, please?
Well, I think it's important for our viewers at home. These days, the state has tried to make access to the court more accessible for everybody, and they've even standardized the forms for everybody to do. And I have found that, that's kind of good and that's bad. There are some times when people use forms when maybe they kind of shouldn't, but I think it's important for people at home to kind of get a judicial perspective of, kind of what's going to happen when they appear before Your Honor. I mean, if they're in agreement, that's one thing, and I think that's important to make sure they have the right paperwork, but also if they're not in agreement and they're arguing about a particular subject.
Well, they have to perform just like any other attorney, and it's mandated that we have to treat them like attorneys. But we've created the self-represented legal program in Will County, and we've made it simpler for the unrepresented person to come in and represent themselves, but they still have to follow the same rules as everybody else. So we try to get them to work it out, and I think that's what you need to do. Even if you have attorneys, you got to work it out.
So what do you think in terms of when people come in to just fill in those kind of forms that we have, all right, Angela?
Well, that would help, especially in Will County. They can go up to the 4th floor law library, and there's helpers up there, and there's diagrams about how to fill out the forms. So there is some back help for them. Also, in the courtroom itself, a lot of attorneys step up and help the self-represented litigants. The forms are streamlined. I think everyday people can understand them now. In the past, we used a lot of judicial language that might be over everybody's normal conversation. So I think we've done a lot to make it accessible to everybody.
Yeah, I believe with divorce and family law, as well as many other areas of the law, with all the revisions and the law changes that inevitably come from the legislature, it's getting more and more specialized, more and more difficult to even practice for attorneys in multiple areas. I would think it would be very tough for someone to come in a pro se, self-represented situation and be able to navigate decision-making, support, visitation, division of property, almost to the point where maybe they can't do it in certain cases, especially when there's no agreement, correct?
Yeah, that's correct. So I'm the type of judge that try to mediate between the two parties. I took classes in mediation after I became a judge, not before. And actually, I took one of Angela's classes. She teaches mediation, because I think it's important for the judge to mediate and get them to agree, because sometimes people have high expectations. It's like when you're selling your house. You think that your house is worth $300,000, but it's actually worth half of that. And, you have to realize that you're not going to get your price. So you try to mediate and get them to some kind of agreement. And what you find out in mediation is that they're pretty close. They just don't realize it. A lot of times it's a lot of emotion, and as you know.
Right.
And we try to get them to work it out.
I'm glad you mentioned about the class and the mediation, and I wanted you to just give a little bit about your background for our viewers so they know who you are, where you're from, and what area you sit.
Well, I grew up in the city of Chicago. I don't know how far back you want to go. I mean, but I grew up.
We don't have that much time tonight, Judge.
I grew up in Chicago. I was married. I was in the manufacturing business. I was a plant manager, production manager, and I went up the line. I even drove a cab for a while after I graduated from college. When I was 35, I went back. I got my bachelor's, and I worked full time, and I went and got my bachelor's that night, and then we had kids, and it wasn't because we had, it wasn't because I had to work. It was, we were married way after we had the kids. I just want to make that clear.
Wait a minute.
So I did college at night, and then when I was 35, I went back to law school. That's what I wanted to do, and that's what I did. So I went to law school. I opened up my own practice. I was a solo practitioner, and I practiced for 18 years in Joliet, representing, just the common folk, the regular people. Yeah, I didn't work for a big law firm or anything like that. I just worked for myself.
Then you were appointed as associate judge when?
In 2013, I was actually the first Hispanic ever appointed a judge in Will County. Yeah, and that was 2013.
And
So I've been a judge 5 years.
For any
yeah.
branch, for any type of law, right?
Right.
Okay.
Right.
Wow.
And now currently you're running for circuit judge?
Yeah, I'm running for circuit judge, and that just gives me a little bit more power. I still want to stay in the family division. I think it's important to stay in that division. I think that some of the problems that come about where people get in trouble or get into, drugs and that kind of stuff starts there. I think that if you can get kids in counseling and get their problems worked out, I think that we can save a lot of these children. So I want to stay there.
And Judge, what particular cases are you hearing now? Is it pre-decree, post-decree, both?
It's all of them. It's all
Okay.
of them. And actually, I'm the acting presiding judge, so I'm in charge of the department. So it's not anything different that I would do if I won the election. Yeah.
You mentioned mediation a little bit earlier, and so just for our viewers at home, just want them to know kind of what exactly is mediation. Angela, is that something you could
I can
speak
talk
to?
about
Yep,
that.
yep.
Yes, and if you can please tell us about your background as well for our viewers.
I graduated from DePaul in 1997. I was, I think, 40 years old. So I had a life before law school. I had quite a few businesses. I'm a little mathematical, so business is my background. But I got divorced, and I saw that should have been more simple. I thought it should be more simple than it was. So I thought I would go to law school and then change the world, which didn't happen. But I found out that I loved law school. I loved the law. I loved the truth of the law. And in law school, I took 2 mediation classes, and that kind of changed my life. I felt like I could make a difference in that area. Because in mediation, it's a settlement process. It's a chance for both sides to meet together, and oftentimes they haven't spoken in a while because of the acrimony. So it's a chance for them to meet with a neutral, which is a mediator, and see if they can resolve their problems. Some of the benefits to mediation is it's cheaper. You have one attorney acting as a mediator that they each pay, or they pay together, so they don't have 2 attorneys fighting. It's also quicker. Instead of preparing and getting ready for trial in the 6 to 9 months that it would take, you can settle it in 1 to 3 hours.
So it's like a precursor then to, so if somebody comes before Your Honor and there's a dispute about parenting time or anything else, the first step is mediation.
Yeah, and it's actually part of our local rules that they have to mediate. But, I like mediation. I think that people should be, they're all adults and they should make their own decisions. So why let a third person make the decisions for you? And that's what happens in my courtroom sometimes. I got to make the decisions for people, and they don't know me. And I think it's better, easier to swallow, I would say, if you worked it out yourself. And a lot of the stuff isn't, it seems difficult, but you can work it out. You can work it out.
Angela, can you speak to, and again, I'm a mediator as well, and I know, and you mentioned sometimes they haven't spoken in some time, and which is it's really troubling because if there's no children, have at it, doesn't matter. But if there's children, look, the most important thing are those little lives, okay? That's the most important thing ever. It
Yes,
doesn't matter
it
what
is.
mom's conveniences are or dad's conveniences are and all that stuff. And there has to be some communication.
There has to be.
And it's not just until the child turns 18. Presumably, the child's gonna graduate from college, going to get married, and
Grandbabies.
Both parents are going to be involved in that.
They will know each other till the day they die.
Right.
They think, okay, I'm going to get divorced. I don't have to deal with that woman or that man again. It's just not true if you have children. You're together forever. And if you can't find a way to live side by side versus together, if you can't figure that out, you are going to be looking at a bad movie for the rest of your life.
Right. And likely spouses or significant others that also come into the picture too. I wanted to ask you, we're talking about mediation. There's obviously court-ordered mediation, and then there's a mediation that you seek on your own, maybe
privately.
even before a court case
Sure.
has been filed.
absolutely.
How does someone come to do that?
A
How
lot
do they
of
know
peop-
about it as opposed to just going to a lawyer and filing a petition and getting in the court system?
They've read about it. They've seen it on TV, maybe. They've had friends who mediated. Statistically, 95% of all cases settle before trial. So if you know that up front, then you might as well work settlement at the beginning. I mean, it's great to be a super trial attorney, but if you're not good at settlement, you're wasting 95% of your life.
And
So, I'm sorry.
No, go ahead.
Okay.
I'm sorry. I interrupted.
So if they come to me for private mediation, that kind of opens the doors to other things. The state has a law that says you must mediate before you go to hearing on custody, or what we used to call custody. But if you do private mediation, you can mediate the financials, you can mediate everything.
Everything.
Which
So-
you can't do in the court-ordered mediation.
So there's different. Court order mediation is just parenting time and decision making
Correct.
exclusively. Now, I know, and I do apologize. I just wanted to mention there's been a couple times when there have been a bit of a financial issue that's been so closely linked
Who's
with
gonna
that
keep the house?
decision, and also like in terms of the support or particular expenses, and I know sometimes just kind of had to hover over that line in order to well,
I know that
guess
feeling.
not get the parties. I mean, in order to enlighten them so that they can make a decision.
Only in court-appointed mediation you're talking about.
Well, right, but even in court-appointed mediation, what I'm saying is like sometimes
You know you're not supposed to mediate the financials, but you can't avoid it almost.
and because that's it's
the core issue.
there-
You're
yeah,
going to get questions on it,
yeah.
right?
One of the things I was going to say when I rudely interrupted Angela was that I've been seeing more and more people that go to mediation first and work out their settlement, and then they
Nice.
come back and they do their divorce after it was mediated, and it saves them a lot of money. Yeah, because ultimately, unless you're a multimillionaire, it's going to end up at the same place,
Right.
and the issues are the same, and it's whether you're willing to realize that the marriage is over and try to get, it's very difficult to get the emotion out of it, but try to get the emotion out of it and treat it like a business. This business is breaking up. Here's how we're going to separate all our business stuff, and it can work. It can work. And, you mentioning financial, people fight over financial issues and end up spending more money than they
Then
had.
it's worth.
Yeah.
There's the financial feasibility portion. I know, just in my practice, when I talk to people, it's not okay. I'm not just looking out for your best interests, but and they're every attorney's different in the way they practice and do things, and it's like okay, so it's not just that; it's the financial feasibility. Do you want to spend $10,000 to save $5,000? We've had people argue over these little Malibu lights that cost $35, and I'm very often telling them, okay, look. You just bought 6 pairs of them.
Yeah.
Do we want to go with the fridge? I mean, it's just one of those things. But a question I had in terms of, because again, it's a local rule, and likewise in a lot of places, a lot of counties, is there a situation where they wouldn't be referred to mediation? So say you had a couple people that came in and they're just so doggone stubborn that there's nothing that you could say or do. Now, I know mediators are fantastic. They've done wonders in cases I've had in terms of, okay, well, didn't see that coming. Okay, wow, we have an agreement. Incredible. But where, mediation is deemed to be like not feasible.
I've had some cases in front of me where the attorneys, they were attorney cases where they have told me their clients are not going to agree on anything. And mediation is just an added cost. And if I feel that, sizing it all up, if I feel that it is a waste of time and money, I won't force them to go to mediation. But then they're going to have to realize that whatever decision I make, they're going to be stuck with.
And it's going to be based upon however long that trial's going to last. If it's going to be a day, a week, a month, that's the thumbnail sketch of their life that you're going to hear, and you're going to rule on the evidence that's been presented.
And remember, if they go to trial, it's not private. If they come to an agreement in mediation, it's private. People don't have to hear about their life. So there's so many advantages to mediation. I think that's why statistically we settle. I think in my practice, I think I'm close to the 90-95% of settlement. and even some cases that, oh, nobody, you're not going to get anywhere with these people. If I don't get a full agreement, I can get some temporary agreements or some partial agreements, which still helps push them along the path, to the end.
To get them taken care of.
Some resolution.
Right.
And some people are just emotionally unable to work it out. I mean, I've had people in front of me that literally it's kind of bizarre. It's almost like you're watching a sitcom where they stand in front of me and they'll say, Judge, I'm not talking to him. Could you tell him this? And then the other person will say, I'm not talking to her either. And I just, I don't lose my patience, but I tell them, what are you guys, adults? Go out in the hallway and work this out, or I'm going to make the decision, and you're not going to like it.
Right.
And they go out in the hallway and they do work it out. So, ultimately, if I mediate it and they can't work it out, I'm going to make the decision for them. So people kind of tend to try to work it out.
And that's that. The decision you make is the decision you make.
That's it.
Unless
No
they
more
make an
argument,
appeal or
no more
anything.
discussion, it's
So,
done.
Angela, you were talking about it being private. So,
Yes.
Let's just say, the parties mediated. We either don't have an agreement or maybe a partial. And you know what? I want to subpoena her because she was privy to some information that's pretty important to our cases. Is that something I'm able to do?
No, you're not. Mediation is considered a settlement conference, and as such, you can't disclose what they talked about. You're not supposed to tell the judge who was the good guy or the bad guy, or who caused trouble or anything like that. When you give a report, which we're required to do, after mediation, we say they agreed, they didn't agree, they partially agreed, or they didn't show up, or they didn't cooperate. But that's about as far as you should go.
Let me. I'm sorry.
I was going to say, if we resolve it in mediation, and nothing's been filed with the court yet, and you as an attorney, they would like you to prepare the agreement.
Oh, right.
What do you do at that
Yeah.
point?
We're not allowed to prepare the agreement because then we're acting like an attorney for two people, which is against our canons.
Are you allowed to even make a referral,
If
ethically?
If you make a referral, you have to refer three people.
Okay.
You can write a letter of agreement that pinpoints all the different levels of agreement and give that to the two attorneys or for them to
Right.
take
Yeah.
with.
Mhm.
But
But
you
you
don't
can't
want to
bring it.
have them sign it.
And they
Right.
can't waive the conflict and
No, they
allow-
cannot.
okay.
Yeah.
That's interesting to know.
Yeah, and then you very often tell the parties, hey, listen, this is your agreement. It's not binding until
A
you review
judge
with your
signs it.
lawyers and the judge signs everything and you go.
Because they could agree to something that's, the court will never let them. Like
Right.
I want Joey 6 months out of the year, and then my wife will have Joey 6 months. The judge is never going to say yes.
Well,
Yes.
you remember those
You can't
tapes
agree
in-
to things the judge won't say
Yeah,
yes to.
you reminded me of a tape in mediation where they had something where one parent wanted one child and didn't want the other child. That's like a classic, at least that they showed in
Yeah.
my mediation training, which is just, so that's important. Well, let me ask you this too, is we're talking about the best interest kind of thing. If, and in mediation, I want to talk about the training in a little bit here, but what happens, so let's say we have a situation where, maybe there is an order of protection in place, or maybe there's not an order of protection in place, but one party is deathly afraid of the other party, and, hey, look, you don't have my address, and so, generally mediation takes place
We call it
together.
conference, where there's three of you together. That's a conference style. We do shuttle mediation where we have one person either on the phone. I've done it with someone from California on the phone, or an OP, I'll have one person on the phone. Or you have them in a different room, and you shuttle back and forth between the two, and you carry the offer and the demands and the offers back and forth. That's pretty common, too.
What happens if you discover an issue that directly affects the well-being of the children? Is that something, we talked about things being private, and, people should know. Is that something, are you
talking
a
about-
mandatory reporter?
We are not. Neither are guardian ad litem, surprisingly enough. We're not mandatory reporters, but there's nothing that stops us from reporting abuse of a child.
Or in any of those
usually-
cases, going to the judge?
Mediators shouldn't, I don't think a mediator should approach the judge with that. A GIL should.
Okay. Let's talk about the difference between the two and the 604B and all that. Let's get into that a little bit.
Well, let's find out what the requirements are
sure.
for
Okay.
for a mediator.
Great.
What,
Surprisingly, to become a mediator, besides being, to be a family law mediator, which is a court-ordered mediator, you either have to be an attorney or a master's level social work, some level of psychology or social work. You also have to have completed a 40-hour plus 5 hours, which I'll explain, course. 40 hours in the process of mediation, the 5 hours is in understanding mental illness, drug addictions, different things that impact on a person's ability to negotiate.
It's definitely helpful for a judge.
Yeah.
Very helpful, very helpful.
Well, we had a 45-hour class that we put together, and it was an amazing thing. And its focus was on families with addictions, because I see a lot more parents that have drug and alcohol issues. And how do you negotiate with that? And how do you come to settlements with those issues kind of surrounding the problem?
And it could be even a prescription drug
Oh, a lot
addiction,
of
so
that.
it's not necessarily illegal drugs, but abuse of prescriptions that
Correct.
have been prescribed.
Correct. Everyone's under stress, and in a divorce, that stress is blown up.
So in addition to those requirements, is there a continuing requirement?
There is. I don't remember what it is for mediation. I'm not sure. I know for GIL, you have to do the initial 10-hour class, which I've taught numerous years, to be certified, or we don't call it certified, to have a...
To continue to be on the list.
to be on the
right,
list. And then you have to have so many hours every 2 years.
2 years. And I thought for mediation it was like 4 kind of hours. I'm a little vague on that too.
I don't remember.
I know it's every couple of years.
I do so
as
many
well,
hours
too.
that I
Yeah.
don't have to keep
Right,
track.
it doesn't matter for.
Yeah, and I think, as attorneys and as judges, we have to do continuing legal education. And you can pick, make sure you're certified still as a mediator, pick those kind of classes that have to do with mediation. I think they'll qualify.
Judge, do you think that how many people or attorneys that are before you that are you aware that are that have the requirements to be mediators? Now, I just say that because even if you don't mediate, I think that's just any area of the law. It doesn't even have to be family law. Any area of the law.
It's back to that statistic. If 95% of all cases settle before trial, shouldn't you be good at settlement?
Right.
Yeah, and to become a mediator, you have to take the classes, and we have a list of mediators. But, because I am sitting in the divorce court all the time, I know which attorneys are mediators and which ones are good at mediation and which may not be good at mediation. Most of the time I let the attorneys choose. If they can't choose, then I'll choose.
That's interesting. Just because I know in different counties, the judge will just choose.
Assign the...
Just assign it. And I mean, hey, I'm not wearing the black dress, so I mean, what works for one person, might not work for another. Although I think that if the parties approached a judge and they said, hey, just like you said, you let them pick. Hey, we're in agreement on this person because we know this person has mediated other things. We know our clients. We know the situation. And I think that the attorneys probably at that point would know the situation a little bit better than the judge. So, to be able to allow them to do that.
Yeah, and I give them the opportunity to decide.
Judge, I was always wondering, how did it change your career as a judge after mediation class?
I think it made me a better judge. I really do. I think that you try to get the people to work it out. And sometimes when they're self-represented litigants and I set it for trial because they can't agree on anything, the trial is more like a mediation than anything else.
Because they don't know how to represent them. They don't know how to present evidence and do those kinds of things.
Right. So
Right.
and the pursuit is always justice.
Sure.
And you want to make sure that everybody gets their time in the courtroom, and you try to give each one their word. So I try to mediate it, and they want something that's not going to happen, I tell them.
So
not
that
gonna happen.
that's it, and so they move on from there. I just wanted to hit one thing real. You mentioned self-represented litigants, and I just want to. So much has changed, and hopefully, maybe in the second half here, we'll be able to talk about those things. There's a lot of different terms, and so self-representing litigant is formally, or currently now, it was formerly a pro se litigant. It's the same thing. It's just somebody who is simply representing themselves.
That's correct.
Right.
That's correct.
I think it's part of our continuing efforts to make the courthouse accessible, pro se is probably Latin, I don't know Latin.
Yes.
But self-represented, I think people can understand more. So even though it was confusing for attorneys to change our dialogue,
Me
I
too.
think for participants, it might be helpful.
I just wanted to talk, and what we picked up in the very beginning, and we were talking about these forms, the state authorized forms. And do you find that they're helpful in every case? Because in my just experience, a lot of post-decree things that I do involve the forms not being completed. And so, when you have somebody that probably should have hired an attorney and can afford to hire an attorney, rather than people who don't have children and who don't have any assets. Yeah. So,
Well, you deal with the forms you have, but let's say I have a couple that are fighting over child support, for example, or let's take it to parenting allocation, what used to be called custody, and I get them to agree on their changes that they want to make. I don't write that order for them. I let them write it in plain language because ultimately that's what you want.
right.
So I give them the form and I say, write down your agreement. And once they write it down, I have them sign it, and then I look at it to make sure it's proper, and then I sign it as, so then, because when we get involved as judges, we're not supposed to, first of all, practice law. When we get involved writing these orders for the people, they could always say, well, that's not what I agreed to. The judge wrote that.
Right.
So I try to get them, maybe I'm not conventional in that sense, because some people just write the order for
But
them.
it's better than checking off the box that is just completely, sometimes just vague.
It's a
Right.
cookie cutter.
Yeah.
Yeah. So they come in with self-represented litigant judgment of dissolution of marriage. I look through with the judgment. I said, well, you don't have any information here on your debt. What's happening with the debt? And I make them write that out. Give it back to them. You know what? You got to fill this form out as much as you can.
And you get a lot of resistance, don't you? Nobody wants to fill out a form. Nobody wants to put
Well,
all that stuff in there.
it's explained to them that they're representing themselves,
Right.
but they still want me to give them legal advice,
can't.
and I can't do that.
Right.
It's against my rules. So
You also have 1 day or 2 days a month that one of the judges does a pro se day.
yeah,
Self-represented litigant day, we're still calling it pro se
yeah,
day.
yeah. She does that every month, twice a month, and she has outside attorneys come in and help.
Right, to help write the orders and to explain a little bit and maybe do a little mini mediation.
Yes, we have
Yeah.
mediators there to
Yeah.
help.
And the reason we don't do it in all the courtrooms is because that's too much work for the private attorneys. I mean, if I had 2 days and this,
Yeah.
we have 5 divorce judges or family law judges, and if each one of us took a day, the private attorneys would be working for free most of the time and not, concentrating on their practice.
Sure.
That's right. There's always someone who will step up and help you with an order, but not every time, correct?
That's right.
Okay,
Yeah.
Honorable David Garcia and Angela Henderson, thank you so
Thanks.
much for
Thank you
joining
very
us
much.
on this
This was
version of Legal
enjoyable.
Action. And Jesse is always my co-host. We'll
Dave.
see you next time on Legal Action. Take care.
Testing. Why did the girl ask the mushroom to dance? Because he was a fun guy.